On January 8th, the Supreme Court invalidated the remission granted to 11 men convicted in the Bilkis Bano gangrape case. The court unequivocally declared the Gujarat government's act of remitting their sentences and releasing them as illegal. But what next in this case now? Turning our attention to the future proceedings in this case, the spotlight is now on the Maharashtra government and whether it will extend any relief to the 11 convicts. The Supreme Court in its order has outlined that while the convicts can seek remission, it is imperative for them to be incarcerated during this process. The court clarified that the Maharashtra state is the appropriate authority to decide on remission applications, leaving the door open for the convicts to approach the state in the future. Now, the outcome, however, hinges on the remission policy of the state, among other factors. Despite the convicts pleading to remain outside prison and secure their liberty, the Supreme Court firmly asserted that such a plea could not be entertained, emphasizing that the right to liberty is forfeited once convicted and sentenced to imprisonment. The judgment reveals a previous attempt by one of the convicts, Radheshyam Shah, to secure early release. Shah had approached the Maharashtra government, the BJP-Shiv Sena coalition, seeking release on August 1, 2019. However, both the special CBI judge in Mumbai and the CBI opposed his early release, citing a 2008 government resolution that mandated a minimum imprisonment of 28 years before applying for remission for such serious crimes. The government sought opinions from the CBI, the investigating agency, and the presiding judge of the special CBI court in Mumbai. Both entities recommended against leniency, emphasizing Shah's active participation in the heinous crime and the seriousness of the offences. Despite these recommendations, the rest of the convicts approached the superintendent of Godhra sub-jail, seeking the opinion of the CBI court. In a report dated March 22, 2021, the court stated that since the men were convicted in Maharashtra, the state's remission policy would apply. The special judge, having examined remission guidelines dating back to 1978, 1992, and 2008, highlighted that the 2008 government resolution would prevail. Now, this resolution empowers the state government to remit a convict sentence only after they undergo imprisonment without specific guidelines on excess duration. The special CBI court identified a category applicable to the convicts related to crimes against women and children, involving exceptional violence with a minimum imprisonment of 28 years before applying for remission. Having already spent more than 14 to 15 years in prison since their 2008 conviction, the convicts argued in the Supreme Court that the remission policy applicable to them should be that which was in force at the time of their conviction. The state of Maharashtra, with its updated remission policy, becomes the potential avenue for the convicts to seek release based on time served and other circumstances. The evolving legal complexity surrounding remission in the Bilkis Bano gangrape case underscore the challenges and uncertainties ahead.